And welcome to the Week 1, Chapter 1 video lecture. In this particular chapter, we're going to deal with courts, crime, law, and controversy. We're going to go over the concepts that you'll be responsible for in Chapter 1, and we'll explain them in more detail and get you up to speed on understanding every one of them. Now again, as I've said in my other video about how to do well in a law class, once you understand these concepts, you want to write them down in your own words as single definitions of each concept with the absolute minimum amount of words necessary so that you can put as many concepts together in your outline of Chapter 1 as you possibly can. And then you do that for each chapter. And if you do that, you'll do very well in the class because you'll have everything you need. All right, let's go into the learning objectives for this class, for this particular chapter. First is we're going to describe how the courts are related to the other components of the criminal justice system, and we'll see that without courts there would not be enforcement of the law. In fact, there's no way under our system to simply railroad someone into a penalty for a criminal act. You can't just have vigilante justice and people hanging people because they think that they're guilty and they need to be hung, that kind of thing. It's not allowed any longer. It was never really allowed to begin with, even in our history, but it was done from time to time. All right, let's discuss also we're going to discuss the major types of courts that are found in the United States. We'll see that there are federal courts, there are local courts through the state that are sponsored by the state. There are courts even of the Indian tribes. There are courts of all sorts within all those categories of courts. And we'll go through all those to give you a good rundown to make you at least understand what types of courts there are in the United States and a little bit about what kind of jurisdiction each of them has. Then number 3, we're going to identify the most important actors in the courthouse. We'll see the prosecutor, defense attorney, the judge, of course, even the bailiffs and the clerks are all important actors in the courthouse. There are witnesses, there are victims, there are people who are just interested, the public. Those are all important actors in the courthouse. And the public, of course, is allowed to come into any criminal case because we do not allow trials to be done in secret. That way we prevent the government from railroading people into convictions and penalties. All right, number 4 is we're going to list the steps in a typical felony prosecution so we can get an idea of how we go through that process. The reason we go through this in the felony more so than in misdemeanors is misdemeanors tend to be very, very simple. We have a complaint and we go to trial. It's pretty much that way, except for a few little steps in between that we might undertake in a misdemeanor. But in the felony prosecution, there's several steps we have to take in order to get to a final trial for possible sentencing if the person is found guilty. So we'll go through those in more detail. And certainly if you know the steps for a felony prosecution, you'll know the steps for the misdemeanor by simply taking out one very large step in the felony prosecution that's not there in the misdemeanor. Number 5 is we're going to list the 4 key elements of defining law. And we'll get into those specifically. We'll go through that in just a few minutes. And then we're going to identify the 3 key characteristics of common law. And a common law is a kind of law. There are several different kinds of law. There's constitutional law. That's the law that we find within our constitutions. It has the highest source of law. It is the highest source in terms of, you cannot contradict the Constitution. No law can contradict the Constitution. It's that kind of a law. It's supreme among everything. Next, we have statutory law. Those are laws created by legislatures. We have administrative laws created by administrative agencies that have the same effect as statutory law. And then in this very odd category, we call it common law. It's actually law that's made up by courts, and they only make up law when there is no other law for them to use to decide cases. And when they decide a case based on law that they had to make up because there is no law, then the first trial court that had to make up that rule then has that rule essentially reviewed by an appellate court who decides whether that was the right rule to use or not, and will either reverse the case if it's not, or they'll affirm it and then publish it if it is the right rule. And then that rule, as published in the appellate court, then becomes binding on all the trial courts within that jurisdiction, and so now it has the force and effect of law. Now, if If there's several appellate courts and they split on what the rules should be in that particular situation within the same jurisdiction, then we have a Supreme Court that'll break that tie and then come to a single rule eventually. Okay. All right. Next, we're going to explain the importance of the adversary system. We do not have a system of indictment, so to speak, or of they used to call it inquisition, essentially. We don't have a system where we go out and inquire as to whether there are criminal acts and so on. No, we have an adversary system that is based on a prosecutorial role where they go out and investigate a case, decide on whether or not they will file it, even if they think there is a case, and don't have to file it. But if they think there is a case, then they will file it if they feel that's the right thing to do. Again, they don't have to file it. We put the decision on what comes into the court for criminal cases on a single governmental agency. We call it the prosecutor, public prosecutor, and it has different names depending upon what jurisdiction we're dealing with. We'll go through that here in a few minutes too. Next, we're going to name the 4 amendments to the Bill of Rights that deal specifically with criminal procedure. Those 4 amendments are very, very important to our study of the court system, because a good amount of judicial time and resources are spent on making sure that the rights that are guaranteed by the Bill of Rights for those 4 amendments are scrupulously honored in the criminal justice system. There's nothing worse that can be done to an individual by a government than to criminally prosecute them and punish them. It could be as much as death, as we all know, for certain types of crime. So you really can't do anything worse to someone than kill them. But they could do that if they went through the right procedure and got the right verdict. And so essentially, that's why we have so many of these rights written into our Constitution, to limit the power of government, so that they can only get a penalty in a criminal case based on these 4 amendments being scrupulously honored. And we'll go through each and every one of them. All right, let's also we want to identify the major elements of a crime. We'll show that there basically are 2 basic types of elements. One's the mens rea and the other is the actus reus. The mens rea is the guilty mind element of the part of the crime where we judge the state of mind of the person who's committing the act that we think is wrongful. And then we have the wrongful act itself. And we'll see how those elements come together and how different crimes are used different aspects of those same elements of mens rea or actus reus. Those are, of course, Latin terms. And again, mens rea is simply guilty mind. Actus reus means guilty act. All right, we're also going to identify some of the most important legal defenses in American law. There are defenses to crimes. These are one of the few things that have been made at common law. It used to be all crimes were common law. That means that we didn't have a legislature way back in early English times. After William the Conqueror took over England in 1066, he started the first of the court systems that had ended up creating law. They didn't have any legislatures. There was no parliament. And the king, I guess, could make up law if he wanted to, but was probably too busy for doing that. And so the courts would have to make up their own law. And for criminal purposes, they had to make up the law. They had to make up the fact that murder was against the law and was against the criminal law and could be punished by death. They had to make that up as law and then enforce it within the court system itself. So we'll see that since that time, and it's about the 20th century, early part of the 20th century, all criminal laws became statutized rather than through common law. They were all based on the common law, but they added a lot of different crimes to the common law and also modified the common law quite a bit. All right, also we're going to explain how a law in action perspective complements a law on the books approach to studying the criminal courts. We'll see what that means here when we get into that in a few minutes. And then we're going to distinguish between the crime control model of the criminal justice system and then the due process model of the same system of criminal justice. We're also going to talk about the Dillon Roof case. We're also going to contrast that with the George Zimmerman case. And then we're going to look at, other than the court system, we want to know who played a role in Dillon's arrest and apprehension and to what extent. And we'll see how a case was brought through the system in that case. All right, let's look at several different kind of important ideas for you to think about. First of all, murder and non-negligent homicides, which are the criminal type. Negligent homicides means you could kill someone but never intend to do that. You're probably not going to find yourself on the wrong end of a criminal prosecution, because normally speaking, if you, let's say, get in a car accident and it happens to be that you are unfortunate enough to kill somebody as a result, probably you're not going to be criminally prosecuted for it, probably not. Although there are some negligent homicides that we can prosecute you for. The typical non-negligent homicides and murders are ones where the murder or the homicide is actually intentional, you intended to kill. Then we're getting into the crime area typically. It's just less than 1/10 to 1% of all criminal arrests are for murder or for the non-negligent homicide cases. They're a very small percentage of the arrests. And by the way, it's very interesting that homicides, which simply means a generic term for many different ways in which someone was killed by another person, where police get involved, it happens to be that only 20% of those cases that we know about, it means we know the person has been killed by another person, only 20% of those cases are actually solved according to the FBI stats. And solved simply means that there was an arrest, does not mean there was a conviction or that someone was punished as a result. And so it's kind of scary about the fact that people are getting away with murder on a pretty heavy basis in the United States. All right, also I want you to know that the death penalty is sought in only a very small fraction of even murder cases, even first-degree murder cases. It is very, very rare. It's something that is usually withheld except for the most egregious type of murders. Usually, in fact, now it actually requires what we call special circumstances in addition to first-degree murder in order to get the death penalty. And that usually means something like lying in wait, murder for hire, murdering more than one person in one incident, that sort of thing. Also, there's changes in popular culture that affect America's legal institutions. One of them is the CSI effect, which is the phenomenon where juries have now come to expect sophisticated forensic evidence in almost every case, even the most mundane of cases. And this has to do with what they see on television. Interestingly, it could be a theft case, a petty theft case in Walmart, and they will want to see some sort of forensic evidence. Why, I don't know. And they'll even ask, where's the DNA? Well, DNA doesn't have much to do with, a petty theft case in Walmart where the security guard happens to see someone walking off with something. We really don't care. They arrested the person they saw stealing it. We don't need to look into that person's DNA. It has nothing to do with it. But they're looking for that stuff now. It's very, very, very strange phenomenon. And it's strange for another reason, is that some of the forensic evidence is really not as reliable as people might have thought it was, and it's not anything like it is on television. And so it's just, it's affecting our legal system, because if jurors expect it and they don't get it, they probably won't go with a guilty verdict, maybe because it's not there. And that sometimes is unfortunate. All right, we also have changes in society that end up in the courthouses. And what that means is that a lot of things are happening out there. A lot of very strange things are going on, and including new kinds of crimes that come out from time to time, and then they end up in the courthouses as criminal cases in one state or another. And we will get into that a little bit more as we go through this process. Also, does the criminal law inhibit justice as a function of racial biases? There's quite a bit of thought about that. One of the reasons why is that it's well known that if you want to take the largest number of people accused of and penalized for very heavy crimes, you will find that the vast majority of them are minority groups. Typically, you'll see a large number being black, a large number being Hispanic, and much fewer being white. And so the idea has come up that somehow the idea of justice, which should be equally distributed among all people and fair to everyone, is sort of unfair. And there's a lot of controversy over that issue. Some people think that that's because most of the minorities tend to be poorer and have less to lose, and so maybe more involved in crime. Other people say no, it's the police are going after the minorities, and so they're focusing all of their resources on going after the minorities and not the whites. And so we're seeing more minorities going through the process of being criminally prosecuted and penalized. And so, for instance, they just may not focus their energies if the person is white, kind of thing. So it's obviously going to be a real issue that's going to be around for a long time, because it's not likely that those numbers are going to change dramatically over the next decade or two. So we're going to see the controversy getting more and more adamant. And one of those things were the issue of the Zimmerman trial, which was a criminal trial where George Zimmerman ended up shooting a black youth who he got into a fight with, apparently, after trailing after this black youth and apparently harassing him, I guess, in some fashion. At least the black youth thought he was. Black youth started going after Zimmerman. Zimmerman was down on the ground, apparently having his head beaten into the pavement. He took out a gun that he had and was licensed to have, and then shooting the black youth and killed him. And in Florida, there is a stand your ground law, which in California there is no such thing. But in Florida, you can stand your ground. You do not have to try to get away from someone who is causing you great bodily injury and could possibly kill you. You're in California, for instance, you're required to first see if you can run away before you can kill them. In Florida, you don't have to do that. If someone's subjecting you to great bodily injury and a possible death, you can shoot them right then and there. The only way you can do that in California is if you're in your house and someone breaks into your house. Then you can shoot them, and that's it for California. So you can see there's difference in the states, but you can see also where this Zimmerman, he would be considered white, and we had a black youth as the other party to this terrible situation. And now there's an issue. Was justice done when Zimmerman got a not guilty verdict and was let go after shooting and killing this black youth, who apparently wasn't doing anything other than actually going to the 7-Eleven and picking up a few items to eat and drink. So very, if you want to fuel the idea of there being little or no justice in the system as to minorities, that would definitely fuel it for sure. All right, let's look at the components of the criminal justice system. In addition to the courts, which are central really to the criminal justice system, because you cannot have a criminal justice system without the courts. Without the courts, there's no legal way in which to either have a trial or exact a penalty if there's a verdict of guilty. But in addition to the courts, there are two other main components. One's police and the other is corrections. So police tend to go out and investigate crime. They tend to arrest people. They bring them into the system under arrest. They now have to go through a public prosecutor that might be considered one and the same with police, although they're not actually the same. And the police will then submit the case to the prosecutor. If the prosecutor says, they say, yes, we think you have a good case, and it is the right thing to do to prosecute it, they will file a case in the criminal courts. Without the prosecutor filing a criminal case in the courts, there is no criminal case. Once you go through the process, you go through a trial, you get a guilty verdict, person is sentenced to some form of correction where it's person's freedom is taken away, either through county jail or state prison. Then we get into the corrections section where they take the person into custody and keep them there, basically out of all the limelight and very inconvenienced for a period of time, which could be their lifetime, and it can even subject them to death. So if you look at the actual diagram we have, where we have the courts, of course, we have police, and outside of that is the public. But this other one that's corrections is both institutional corrections, which would be your county jails and your state prisons and federal prisons, and then also community-based corrections, which would be your probation and parole. So corrections is really both an institutional aspect and a probation and parole aspect, so that it's not entirely always keeping people in direct custody for purposes of correction, but probation is considered for instance, a correctional system, and so is parole as well. So we don't if we want to lump them all together and call them corrections, it's still both institutional and community based at the same time. Okay, let's go into the courts. Courts are related to the rest of the criminal justice systems as follows. First, there's an interdependency that the courts have on the other aspects of the criminal justice system. They are interdependent in that the courts must have the prosecutor and the police to bring cases to the courts, or the courts are not involved in the criminal justice system. They may have civil cases, but they won't be having criminal cases. And so you see the courts are dependent on one party bringing cases to them. And in this case, it would be the public prosecutor with the police having done the investigation. They're interdependent in that sense. Also, the courts are also interdependent on the correctional system. If they're going to sentence someone to county jail or state prison, there better be a county jail or state prison system to house them, or there won't be a penalty. We'll have to just let them go because there's nothing that we can do with them. Okay, so the problem with this interdependence is that each and every one of the agencies that's involved in this, including police, prosecutors, even the probation departments, the parole departments, the sheriff for the local jail sentences, and for the state for the state prisons, or the federal government for the federal prisons. They all have different goals, they have different histories, they have different operating procedures, they all have different policies on how they deal with things. And so even though the courts are interdependent on these other agencies and must interact with them, they're often faced with some very interesting differences. And let me just give you one example. It's well known in Humboldt County, California. It is a county that has been for a very long time been the marijuana growing capital of California, and there's so much of that going on, even during times when marijuana was illegal and even felony illegal. So much of that was going on. So many people were dependent on the marijuana industry that both sheriffs, police department people who ran for election to be the head police department officers and the head prosecutors all campaigned on the basis they would not, repeat, would not enforce the marijuana laws in that county. Okay, that means you will not be finding any marijuana cases coming into Humboldt County courts. Why? Because the prosecutor doesn't want to file them. They think it's wrong. Even though that's, the law says that it's against the law, we're just not going to enforce it. That's the right of the prosecutor. And so you can see their policy is much different than it would be, let's say, in Los Angeles, where Los Angeles they prosecute you without even thinking about it for marijuana cases on a routine basis. Many people went to state prison on the basis of selling or even possessing even small amounts of marijuana. Even a seed of marijuana can get you a felony for 5 years or more during times when I was much younger. But the system's also what we call fragmented. That means that it's in different pieces, and these pieces don't necessarily cooperate very well. They're in many different pieces. Let me just go through a typical situation. You might have a police agency, let's say a city police agency. They have their own, again, goals, histories, operating procedures, and policies. They decide on what kind of cases they're going to investigate and what kind of cases they're just not going to investigate because they don't care. Then you've got the public prosecutors, and they're completely independent of police. In fact, the last thing you want to be known as in a prosecutor role is that you are sort of the rubber stamp for police, because people don't like that. Police departments sometimes can be very, very biased and do the wrong thing in a justice sense, and we want the prosecutor to be able to stop that. So they are required, and they're a political office in everywhere except maybe the federal government where they're appointed. It is a political office. You are elected to being the district attorney, for instance, for the county. That is your public prosecutor. They're a head law enforcement officer for the county, and they have their own goals, history, operating procedures, and policies. They decide on how they're going to deal with cases. That's entirely up to them. They can file a case even if they don't necessarily believe very much in it. As long as they have a sufficient probable cause to believe the person committed the crime, they can file it. They don't have to actually believe in their guilt to beyond a reasonable doubt in order to file a case. They may also know for a fact somebody did a very bad thing and not prosecute them. So you can see how that can be a real problem sometimes when we may let someone go who should be prosecuted. All right, then we go with the court system itself. We have a bit of a fragmentation there because we have different judges in different departments. Each of them has sort of their own goals, histories, operating procedures, and policies. They like certain kind of cases. They don't like other kinds of cases. They can be good for the prosecutor in some kind of cases and not so good for them in other kind of cases. And it can depend on what judge you get. You can have a 40-judge department for the county, and which judge you get might make the difference between whether you win or you lose. Then you go into probation. Probation departments are, again, independent agencies. They're under the control of the courts, yes, but they also have their own goals, history, operating procedures, and policies on how they do things and how they will do their job in terms of both supervising people and creating sentencing guidelines and sentencing recommendations for the courts. All have to do with all their goals, histories, operating procedures, and policies. And then next you have the sheriff for the local jail. How they do their correctional work is all up to them in terms of their goals, history, operating procedures, and policies. They may let certain people go because they don't have enough room. Who do they decide on they're going to let go is entirely up to them. If they can't house somebody and they have to let people go, they can decide on who it is they're going to let go. Same thing with the state prison system. It's a completely different, it's typically a Department of Corrections as we have in California, completely different and independent agency. It's not bound to anybody. It will do what the law requires of it, but that's it. That's the only thing that there is any control over. And they have their own goals, histories, operating procedures, and policies, and they all can do whatever they want in terms of, at least within the law, they can do just about anything. So now we've got many of the actors within the actual criminal cases, which are victims, witnesses, and others related to the case, are private citizens. They have no obligation to any government whatsoever. And so you can see how there is some interdependency, but you've got a fragmented system where everyone's sort of doing their own thing. So I want you to keep that in mind when we go through this court system, because keep in mind that we have an interdependent system that's quite fragmented, and it causes quite a bit of conflict over time, for sure. All right, the tensions and conflicts. First, there's a structural arrangement of the system that can cause these. For instance, police may be under a lot of pressure to find someone who did a really heinous act. The prosecutor says, well, I'm sorry, you don't have enough evidence. We're not going to file. Boy, you've got some problems, because the police are going to try to pressure the prosecutor into filing, and the prosecutor is going to say, no, I'm not taking a case into court that I'm not going to win. And you just don't have enough evidence. Go out and find more evidence. That's a big conflict area. For instance, you may have a person who's on probation after being convicted. The probation department doesn't really supervise them very well because they think that they're not a problem. They end up going out and murdering somebody. That's going to cause some problems. Lots of tensions and conflicts when one department and the choices that they make don't meet up with the expectations of the public to be safeguarded from that sort of thing. There can also be issues among components of the criminal justice system. It may be that it's not unusual, it does happen from time to time, that police agencies are not looked upon by prosecutors as being particularly honest. And they take a second look at every case because they've been hoodwinked a few times on cases and found out later that the police were lying, or some aspect of the case was false, and the police knew it, and that can be a real problem. Sometimes even prosecutors will hide evidence from the defense that they're not allowed to. because they want to get a conviction. Another tension that's going to go on. The defense is going to go crazy when they find out that exonerating evidence was not given to them, and then the person's convicted, maybe even put to death or nearly put to death. That's going to cause a lot of conflicts. There's tensions and conflicts also that result from multiple and conflicting goals if each of these different independent and fragmented agencies that are involved with a central court system, so that we're going to get into a lot of trouble with these different conflicts that are going to come up from time to time, and there's going to be a lot of finger pointing and so on, especially when something bad happens. For instance, a judge has a convicted DUI suspect who's been convicted, has several prior DUIs, and the judge, has the right to set bail, for instance. Prosecutor says, "Judge, don't set any bail on this person. They're too dangerous. They've already been in several accidents. You let this person out, and they're going to kill somebody." And sure enough, court says, "I don't care. I'm going to let them out anyway." And sure enough, they go out and kill somebody in a DUI accident within the next day. That's going to be, you talk about conflict that's going to be involved in that. There's going to be conflict everywhere. People are going to be pointing fingers at the prosecutor. Why didn't you stop that? Police, why didn't you stop them before they killed somebody? Court, why did you give up on this person in custody when they were so dangerous? I mean, it gets to be, incredible conflicts, and you'll see them all over the media, and probably for good reason. All right, let's look at an overview of the U.S. courts. We have first a dual court system. We have a federal and we have a state system. Now, by the way, the states, this is something I want you to know because most people just don't see it this way, but every state within the United States is a separate sovereign government, very much the same as England and France. So California and Arizona are the same as England and France. They're separate sovereign governments. Yes, the states did give up some of their sovereignty to the federal government, which is its own separate sovereign government, but they didn't give away all of it, and so they are separate sovereign governments, and they can try people in their own courts just like any other sovereign government can do for violations of the law of that jurisdiction. So you have the federal government is its own sovereign government. The 50 states are each their own sovereign governments. Each of the Indian tribes is the same as a state, and therefore we have some 70, I think, Indian tribes, all of which are they have their own court systems and their own laws. That's why, by the way, you may know that on the Indian reservations you can have gambling, where within the state itself that they may be within, you can't gamble legally. Well, you can within the Indian tribe because they have their own laws. It is their jurisdiction. It's their territory. So I want you to be sure to know that, because most people think of the states as sort of a subdivision of the federal government, and it is not. We made up the federal government to unify all the states, but that's all. And I want to give them very limited powers, and the rest was kept to the states. So we have a dual system. The federal government can prosecute somebody. The state government can prosecute someone for the same crime, by the way. And yes, and each of them can exact a penalty. You think, well, they can't do that. That's double jeopardy. No, it's not. The reason why is because these are separate sovereign governments, each prosecuting. It's the same as if England prosecuted someone for violating the law in England, and France did the same for the same act in France. As long as both had jurisdiction over that person, because maybe some of the part of the crime happened in England, part of it happened in France, both of them can prosecute them, and both of them can exact a penalty from them. All right. Beyond the fact that we have a federal system, we have a state system, we also have trial courts within each of those systems. Each system has its own trial courts, appellate courts, and Supreme Court. Trial courts are the courts where original cases are filed, trials are held, verdicts are rendered. The verdicts then can be appealed by right to one appellate court in every system. You have one right to appeal. It's an absolute right. If you want to appeal your case, you may do so. You do not have a right to go to the Supreme Court in most cases, except for some rare exceptions. And so you have only one right of appeal in these court systems, whether it's state or federal. The Supreme Court would have to agree to take your case, which they could do if they wanted to, but they don't have to, and they rarely do. I think they typically take about 250 cases a year out of 6,000 to 9,000 petitions that they see, just to give you an idea of how few cases actually get to the Supreme Court level. That's true in both the states and the federal government. Okay, so you have that dual court system. So remember, if something happens within California that is against the criminal law, California can prosecute them. If that same act within California violates a federal criminal law, the federal government can prosecute them as well for the same exact act. This happened, by the way, in the case of Rodney King. In the Rodney King case, the state prosecuted the police who were involved in the beating of Rodney King, consistent with an arrest that they were making of him. And the jury found them not guilty. The federal government then prosecuted them for the crime it was actually a discrimination crime, discriminating against someone under color of authority, and it was a criminal act, and they were found guilty and punished there. So that's just a good example of the fact that those separate sovereigns can each prosecute the same person for the same act, so long as it's within their jurisdiction. California is within the federal jurisdiction because the federal government has jurisdiction over the entire United States and its territories, but California only has jurisdiction over the territory of California itself. So it has to happen in California before California can prosecute someone. All right, the trial courts, again, are where jurors are sworn, witnesses are questioned. They're sometimes called the lower courts, and there's also the major trial courts. What happens is within the court system itself, state or federal, they have the lower courts, which process certain types of cases. They basically just they divvy up the work into different courts, even within the same system. So you might have one trial court in the federal system that does all of heavy crimes only. That's all they do. They may do only law and motion work. They may do all sorts of things. It depends on how they decide to divide up the work. And so just know that within the same system itself, we sometimes create courts for different, very specific purposes. In California, it's not unusual to have a juvenile court, just dealing with juvenile cases. That's all they do. That's entirely everything that they do. And they have plenty of cases, not like they don't have enough work. And then there's other lower courts where all they do is process felony cases through a preliminary hearing, and that's all they do. They don't take the case to court and to trial. They simply process the felony case to see if it has sufficient probable cause, and then send it off to another major court for the final phases of the felony prosecution through the trial. Appellate courts, they review decisions that are made by trial courts, and most often these will be the major trial courts, because you have to have a trial and you have to have a verdict before you can appeal it. And so you won't get appellate court jurisdiction until you have a verdict, typically. And so the appellate courts, they don't hold any trials. They don't have jurors. They don't have witnesses. We just have lawyers arguing whether or not an error occurred in the trial court, upon which they should reverse the verdict and order a new trial. Essentially, that's all that they do. And so, again, you have one right to an appeal, and so you have a right to appeal to the appellate courts, but not the Supreme Court within any of these jurisdictions. But then you have that one right. If you think something went wrong in your trial, you did not get a fair trial for any of the errors that you may think that were out there, then you can go ahead and ask that the appellate court overturn it. And you have to get the case to the appellate court by filing a document asking for them to take the appeal. And they will take it by right, so long as you file that piece of paper within the time limit that you have. Now, the U.S. Supreme Court or the state Supreme Court, as the case may be, it's a court of last resort within the jurisdiction. Cases are hand-selected by the justices themselves, typically. There are a few exceptions to that, but otherwise, they will only take cases that they want to take. Typically, the U.S. Supreme Court hears fewer than 85 cases a year. Certainly, they couldn't do more than 250 cases a year. They don't even in session that long to be able to hear that many cases. They usually only hear very big cases that have a big impact on society as a whole and very important for them to decide. And otherwise, they don't waste their time on other cases. A good thinking point is Roe versus Wade. Roe versus Wade, of course, was a challenge of a Texas law that prohibited abortions except to save a woman's life. And the court was very careful to balance the right of a woman seeking an abortion within the state's interest in protecting maternal health and the potential life of a fetus. But we all know the decision. What happened was that they struck down the law that prohibited abortions except to save the woman's life, which essentially opened up abortions to being allowed for any reason or no reason at all, and prohibited governments throughout the United States, because this was a Supreme Court ruling, prohibited any government from prohibiting a woman from having an abortion at all, and no matter what the reason was. And now the question here is what allows the Supreme Court to hear this kind of case? Well, number one is it came under some of the Bill of Rights. Does a woman have the right to an abortion, and such that the government can prohibit it? And it came under First Amendment rights. It came under maybe some of the other possible rights. We'd have to go back and read the decision on which kind of rights it was, but it was one of the Bill of Rights that was used as a basis for why this was against the Constitution for any state to prohibit abortions. And it might have much to do with religion, by the way, which is one of the reasons why they might have gone the way they did. We'd have to go actually read the decision, but it might have been that one of the constitutional prohibitions on government is that it cannot facilitate any particular religion, and one of the reasons why they don't like abortions is because of religious reasons, and so that might have been one of the reasons why they went with Roe versus Wade as they did. So the question is, do you agree with that choice, that a court should decide the fate of a woman's choice in the first place? Well, it really doesn't make too much difference, because in this case, if they could not have gone to the Supreme Court, they had no one to turn to. Texas was not going to change the law. They were still going to prosecute people for having abortions for people who were not allowed to have abortions. And so if they couldn't find a constitutional, they could not find that the law was unconstitutional and therefore void, then they had no basis for challenging it, because the state Supreme Court wasn't going to do that. We assume they went to the state Supreme Court first. We'd have to go back to see the decision, but that's probably what happened, and they didn't get where they wanted to go, so they had to go to the United States Supreme Court to see what happens. All right, let's identify the actors in the courthouse. First is the prosecutor. That's the first, because without the prosecutor, there are no filed cases. Without the prosecutor, there are no criminal cases, because you cannot have private people coming in and filing criminal cases. It's not allowed. The only one who can do that is the prosecutor. It is the public prosecutor. They're given that right by law, and only they can file cases. Now, it happens to be that within a state system, we may have local public prosecutors. We call them district attorneys in California. They are the head law enforcement officer for the county. And then we have the Attorney General's office. That's the head law enforcement officer for the state. And the Attorney General for the state can oversee and even contradict the local prosecutors. But eventually, one prosecutor or another is going to decide on whether there is a case and whether it's going to be filed or not. Nobody else can do that within our system. We used to have inquisitions way back when as the method for bringing up criminal cases, where inquisitors would just go out and talk to people and say, was there any criminal acts that you noticed happening in the community since we've been here last? And then if someone says, oh yes, such and such person was murdered, and so they would go out and they bring in witnesses and they would inquire. And that inquisition could end up with a prosecution of someone, and could end up with a criminal case being brought that way. We do not use inquisition. We use an adversary proceeding and the adversary, your adversary is the state itself through the prosecutor as a government agency. Then you have defense attorneys. These are people who defend the person who is accused of the crime. And then, of course, you have judges who are the referees of the actual trial itself and the other proceedings where we guarantee the constitutional rights of people who are accused of crime. And then, of course, you have the defendants, people who have been accused of the crime, and we have victims, we have witnesses, we have others who may have something to do with the case or be involved in the case in some fashion. All right, let's look at first the justice professionals. First, the police. We have federal police, we have state police, we have local sheriffs, local police departments such as city police departments, special districts themselves such as colleges and universities tend to have their own police agencies. And then we have private security as well. Private security really is not a governmental agency, it's private, so it's sort of a subset of all of these other ones. Then, of course, you have the lawyers who are prosecutors, public defenders, court-appointed defense attorneys, private defense attorneys, judges, and law clerks within the system. The law clerks help the judges and the attorneys do their work. You have court support staff. These are clerks of the court, court reporters, pretrial services personnel who actually go through and decide on what recommendations there should be for bail, for instance, when someone comes in. There are bailiffs who keep order within the court itself. You have court administrators who keep everything running the way it needs to run. You have victim witness assistance program personnel, you have rape crisis centers, and so on. You have correctional officials, which are probation officers, jail employees, prison employees, drug rehabilitation program personnel, and so on in the correctional system. By the way, as far as who is the biggest and baddest and the most powerful person in the criminal court system, it is the prosecutor. Again, without the prosecutor, you will not have a criminal case. And if you have a filing by a public prosecutor, you have a criminal case you have to deal with, whether you like it or not. Even if you're not guilty, you still have to deal with it. There's nothing you can do about it. Okay. Of course, we also have members of the public. These are regular participants. The bail agents might want to know that the person that they put out for bail is coming into court, so they'll be there. You have reporters, social service personnel, select expert witnesses might also come in. You have the irregular participants, which are your defendants, your victims, your witnesses, jurors, and victim advocates. You have just ordinary people from the public who come in and want to see what's going on in the system. That happens as well. All right, let's look at the steps in a typical felony prosecution. This is not true for misdemeanors exactly, except because there's one step number 4, that does not exist for misdemeanors, but otherwise they are the same. But the felony prosecution typically happens with an arrest. It doesn't have to. We don't have to arrest someone to bring them into a criminal court. We could simply send them a letter and say, come on in because we've just filed against you. And if you don't come in, then we'll put out a warrant for your arrest. Then we'll arrest them and bring them in if they don't come in. That we can do that too. But they got to come in somehow, so they got to be notified that they have something against them. And if they won't come in voluntarily, we'll have to go out and bring them in handcuffs. Second is the initial appearance. That's where the person comes before the court for the first time. That's when they are told of the charges that have been issued against them. They are either appointed an attorney or they bring in their own attorney. They will typically enter a plea of guilty or not guilty or no contest to the charge or charges. Typically be not guilty, because not guilty plea does not mean that they're saying they're not guilty. What it says is that you have to prove that I'm guilty, so go ahead and prove it. So the plea of not guilty simply means prove it. It doesn't mean that it's not someone saying that they are not guilty, as the media seems to hype up all the time. It's simply it's a way of pleading in a court to charges. All right, bail is usually part of the first initial appearance often, but bail can actually be looked at any time during the process, even after conviction. Bail is simply a process by which someone can get out of custody while the case is pending, if it is allowed, and someone puts up a large sum of money or other valuable property on their promise to come in, and if they breach that promise, that property is forfeited. Okay, next is step number 4, and in this case, for felonies only, we, as part of our system, it's been that way since even early English times, before you can go to trial in a felony criminal case, you must first have a court agree that there is at least probable cause to believe that the person has committed the crimes that they are charged with. If a court will not do that, you are going to go no further in that felony prosecution. So that means that the prosecutor must put on enough evidence to convince the court that there is probable cause to believe. And the probable cause simply means that there's a strong suspicion that the person did the crime. It's not by any means anything close to beyond a reasonable doubt kind of proof. Okay. Now you can have that probable cause hearing in two different ways. You can use a grand jury where we literally bring in jurors from the outside. We present the case to them, and we ask them the same question that we would ask a court, and that is there probable cause to believe the person committed the crimes by which they are being charged with? And if they say yes, then they will issue what's called a true bill, and that true bill will then be filed with the court. And then the next thing you're doing is going to a criminal trial, felony trial. Once you get past the grand jury, or sorry, the next one is preliminary hearing. Preliminary hearing is the same thing going on. Instead of in front of a grand jury, it just goes in front of the court, and the court makes up the decision about whether probable cause exists or not. So a grand jury is done in front of literally a jury, and the preliminary hearing is done by the court, hearing the same exact issue, and that is whether or not there's probable cause to believe that someone committed the crimes that they are charged with. And again, if we get past that requirement as a prosecutor, then we go to an arraignment where they are arraigned on the charges that they are found to have had probable cause to believe that they committed. What that arraignment is simply the same as the initial appearance, where they're told what the charges are that are against them, that they're going to go to trial on, because now we're going to trial rather than going to a preliminary hearing, and they enter a plea, once again, to the new charges that have now been filed. Because it's possible, for instance, we could put in a whole bunch of charges in on the original arrest and complaint that is filed, but we can't prove probable cause on all of them, and only some of them will be found to have probable cause, and then only those will be part of the charges that are filed after the preliminary hearing, and then so we rearrange them on the same exact charges, and we ask for a plea of guilty, not guilty, or no contest. Those are the three pleas that they can have. They'll typically will plead not guilty, which simply says prove it. Then we'll go through what's called a discovery proceeding. That's where we exchange information between the prosecution and defense. And we can actually, to some extent, go out and look for information outside of the two parties themselves. We can actually bring in third parties, possibly, and we can interview people. We can go and subpoena documents. We can do all sorts of things to discover all the evidence that's available in the case. Then there's the next stage is the pretrial motions, which is where we, if we think that something is not going right and we think the court should order something to take place, such as, let's say, the defendant believes that they were illegally arrested in violation of their constitutional rights and that they should be set free and the charges dismissed under what's called the exclusionary rule, which we'll learn about later, they could file a motion to dismiss the case on the basis of an illegal arrest. Okay, and that would be just one example of a pretrial motion. But pretrial motions are simply, we ask the court to make an order in some fashion based on something that needs to take place before we go to trial. Next are the plea negotiations. If we get past the pretrial motions, we're still going to trial. We may have plea negotiations. Sometimes both parties know they're not going to negotiate because maybe it's a death penalty case and no one's going to be getting off the death penalty, so we're going to trial. But otherwise, the vast majority of cases are negotiated, and they often, 95% of the time, will end up being negotiated to settlement without a trial. And if we don't, then we're going to go to the trial. We will have a trial in front of a jury. If the jury is asked for by the defendant, he will get a jury. He doesn't have to have one. He can just have the court decide if he wants to. But otherwise, it's going to be a jury trial in a criminal matter in most jurisdictions. If we have a verdict of guilty on one or more charges, then there'll be a sentencing hearing where the judge will decide on what the sentencing should be, and sometimes the jury will decide on if it's a death case. And then after the sentencing, then, if the criminal defendant wants to appeal the decision, they can file their one right of appeal. All right, Let's look at the case close-up on Brown versus Mississippi. This was a race-related murder case of an innocent man by corrupt police. The confessions were based on torture and coercive tactics, and the free and voluntary confessions, the so-called free and voluntary confessions that were nothing like it, were put in as evidence, and that's what convicted the person. And what happened here in this case was the Supreme Court ruled that, no, I'm sorry, police, you cannot beat people into confessions. Confession must be absolutely voluntary and something they want to do, and not something that they have to do because you're beating them. And this was it was a tactic the police used to use. And in the 60s, when the case came up, it really set the police into a totally different way of doing things. They actually had to go out and investigate cases instead of bringing in the usual suspects and beating them until somebody confessed, and then they thought they had the right person. Well, that's not always the case. You can beat people into confessing to things that they didn't do, and we didn't want to see that any longer. It's not what we call due process of law. That's not the way we find the people who are truly guilty. That's how we end up putting a lot of people away who are innocent. And in any event, we don't believe in torture anyway, but they were doing it. All right. So the 14th Amendment actually brings in their due process requirement from the federal Constitution as against all the states, so that even though this was a state case, the federal system through the United States Supreme Court could rule that the verdict was illegal because the evidence was not free and voluntary, and therefore order a new trial on the case and set aside the verdict of guilty. Okay, and that's what happened. All right, let's look at the basis of law. Now, the basis of law really is human conflict. There are four key elements defining law. First, that you want to know that law is a body of rules. It's things you can do, it's things you cannot do. It empowers you, and it also prohibits you. It's whatever the law says is what the law is. Law can be from constitutions, it can be from statutes, it can be from administrative regulations, or from the common law. Law is also enacted by public officials, typically, not always, but typically. Law is enacted in a legitimate manner, and law is backed by the force of the state. Now, that's very important with this last one is that you cannot, and this is something, by the way, that's gone back to early Roman times, ancient Roman times. They had one saying, and that was, without law, there is no crime. Okay, you cannot have a crime unless there's a law that allows the government to prosecute people for a violation of that law and then exact a penalty for that. Okay, so law is backed by the force of the state because we give the state the right to enforce the law and exact a penalty for the violation of that law, because it's laws enacted by public officials. Even if it's a court that's doing it, it's still a public official. But we've got law, and you have to violate that law before you can be convicted of a crime and punished. Okay. All right. The law common to the entire land. Louisiana is unique among American states and uses the French civil law system, but still uses common law for crimes, which is very interesting. That's one of the few places in the country where this is still true. They use common law for crimes. Common law means that courts made up the common law. Okay, every state except Louisiana no longer uses the common law for crimes. That means that what the judges made up as crimes back since 1066 AD in England and then in the America was abrogated by legislation as of this very early part of the 20th century. And although even our legislated crimes now were based on the common law to a large extent, they've also modified the common law significantly and added quite a bit of crime that just was not there at common law. Common law was just a system where judges decided on what the law was for crimes. And by the way, they decided that they would only make something a crime if it was a crime in the Bible, because they wanted a higher source for this, because in almost every case the penalty was death back in the early times. And so they literally looked to the Bible to see what things should be crimes. And there's some things that are crimes now, like identity theft, that was not in the Bible. So they refused to make crimes. That's something that was not in the Bible. And so they got to a point where we couldn't have enough crime, or we couldn't have enough definitions of crime because it wasn't in the Bible. In any event, Louisiana still has a common law. It's judge-made law. It's based on this idea of what's called stare decisis, which means the decision will stand. It's another Latin phrase. And what that means is that once these appellate courts rule on the rule itself and affirm that that is the correct rule, it should be used in that kind of case, then it is binding on all the trial courts. So you end up with law that the trial courts have to follow. So you've got law, even though it was never made up by a legislature. And it's basically uncodified. It's just there in the case. The case itself is the law. And so you actually cite the case for what law it is that you think is criminal. Anyway, appellate courts are still a very important source of American law, but they're not making law. They are finding it. That's so they say. In reality, they're making up law. Okay, they say we're finding it because we have to go out and find a law since there is no law. But it's a real problem for judges to be making up law in the criminal world, because it's what they think it should be criminal rather than what the legislature should be thinking is criminal. We shouldn't be having judges making up law in the criminal world, because they're just giving us their personal opinions of what the law should be, rather than what we think the law should be as a society. All right, constitutional law is still an area that is primarily judge-made. That means that the Constitution is the only arbiter or interpreter of the Constitution are the courts. And so they're making up all the law regarding Constitution. Whatever a Constitution means in terms of limitation on the part of government is all in the minds of the judges who decide it. That's absolutely true. And they have a common law tradition as part of that, because they'll make up law. And so you have to go to the cases to find out how the Constitution has been interpreted. Because if it's not interpreted in a certain way in the courts, it's not going to be interpreted that way anywhere that we care about, because the only way you're going to be able to use it in a criminal case is actually in a court case itself. So if it's you can't try a case outside of the courts. You can't just railroad somebody. You have to go through the courts if you want a judgment of conviction and penalize someone. So judge-made case law is vital in determining the meaning of other sources of law. So in essence, what the Constitution means is what the judges say it means. And so that's the reason why judge-made law becomes very, very important, especially in the area of the constitutional rights under the Bill of Rights that are so scrupulously honored by the criminal justice system. All right, let's look at precedent itself, which is simply stare decisis. It simply means a decision will stand. And it simply means that courts will follow what their appellate courts tell them to follow. They must, or their cases will be set aside, and they'll have to do the trial over again. And so the appellate courts tell the trial courts what they should do. And they do that through published decisions. And the highest appellate court is the Supreme Court. The Supreme Court tells the appellate courts what to do. But eventually there will be a decision on what law applies in a given kind of case. And it's through this process of stare decisis where essentially this decision, whatever that final decision is, will stand. And sometimes it goes back and forth between appellate courts to Supreme Court, appellate court, and go back and forth several times before it is actually settled. But once it's settled, then that's the law that we're going to all be scrupulously honoring throughout all the trial courts. All right, so how do you read legal citations? It's very simple. If you look at the chart here, we have first the appellant's name. That's the person who appealed the case. That may have been the criminal defendant in the trial court, but they are the appellant, and they're the first one to be named. And the versus means that's because we have an adversary system. They are versus the respondent. That means the person who's responding to the appeal. So the person who's appealing will be the first name. The person who's responding to the appeal will be the second. Next is the actual volume number of the book of published decisions that you're in. In this case, it's the U.S., which means United States Reports, which is the official reports of the United States Supreme Court. And it starts on page 436. It gives an alternate site here of volume 86 of the Supreme Court Reporter, which is a private reporter of Supreme Court decisions, and that starts at 1602. These are separate bound volumes. This is the official version. This is the unofficial version. Here's another unofficial version. It's the lawyer's edition, second series, volume 16, page 694. The year of the case itself is actually over here. Typically, you will often see these things, alternate sites put together, but the official site is certainly good enough to get to any case through the official site. Now let's look at multiple sources. Courts must know how the cases are interpreted, as well as their location. Sources of American law include constitutions, statutes, administrative regulations, and common law, also called judge-made law. And so we have multiple sources. You have to look at all of those things to make sure that you have all of the law that might apply to a given case. Okay, now let's look at constitutions. They are the highest source of law in the jurisdiction. We may have the federal government, which has the United States Constitution. We may have a state government, which has, for California, is the California Constitution. These constitutions are binding on the jurisdiction. They are often limitations of government power. They can also occasionally empower certain things and certainly give people certain rights, which are basically a way of limiting the power of the government. So the fundamental rules that dictate how people will be governed are created in constitutions. They also create the government itself. They create the guidelines for how the government will be established. They establish principles and general laws of the nation or state. And they define the powers that each branch of government may exercise. We have three branches of government: the executive, the legislative, and the judicial. Okay. All right, let's look at the different branches of the government. Let's consider the three branches. What are they? Of course, we know they're the legislative, the judicial, and the executive. What are the duties of each? The executive branch is the one that whose duty is to enforce the law. The legislative branch has the duty of creating law. The judicial branch has the duty of deciding on whether the government has proved their case to enforce the law. And then if they did, then they will enforce the law by setting a penalty for a criminal case. That's essentially what they do. So the question is, does your state have its own constitution? I'll bet it does, because without it, they couldn't have established their government. So you might want to take a minute and read your constitution or some of the provisions in it. Most of what you'll find in your constitution are limitations on the power of the government and also setting up the government itself and how it will be operated. And you might find that some of these aspects are a bit outdated, because if you were a state way back when Connecticut was formed, for instance, in the 1600s probably, they had probably some very, very antiquated provisions. We also have statutes. These are rules enacted by state or federal legislatures, and they're a product of the legislative process. We know we are a representative form of government. We're all republics. Every state is a republic, and the federal government is a republic. We do not vote directly on legislation. We have representatives that do that for us. We also have local government rules that are also called typically municipal ordinances, but they are rules just like anyone else, and within their jurisdiction, they are absolute. We have administrative regulations. That means that what happens is we have a law that actually creates an administrative agency, and then also gives them certain powers to make law, and not only powers but duties to make law within certain very, very specialized areas. So, for instance, the Federal Communications Commission for the federal government makes up laws on who can have licenses to television stations, what kind of transmissions of all kinds of communication can be done in the United States, and under what circumstances. Congress does not want to deal with those very picky type of situations, so they create the administrative agency to create the rules for us. But they have the same effect as a statute, so they're just as enforceable as any other law. Let's look at administrative policies. You might want to look at some of the rules and regulations that apply to your local area and some of your administrative agencies that may be overseeing some of the things that you do, and take a look at what their regulations are. And maybe someday we might be able to discuss them in one of our discussions. Basically, they create the law by usually by having public hearings and hearing from everybody before they make a decision on what the law will be, but they make it up. Usually they have a board that makes it up. All right, let's look at the adversary system. First, you want to look first at this idea of what's called substantive law. These are rules that create legal obligations. Substantive law is the law that creates the rules by which we must all obey. It could be criminal law, it could be tort law. Torts are civil wrongs rather than criminal wrongs. They can create the law of contract, the law of domestic relations. This is family law kind of stuff. And it could be criminal law. It could be robbery or burglary, are all created as substantive law. That means it's law that will actually be used in court to regulate and enforce legal obligations and duties and rights between parties. Okay. Procedural law, on the other hand, establishes the method of enforcing those obligations. So it will tell, for instance, how you go through the court process. How many days notice you have to give of somebody when you want to file a motion to the court, for instance, might be a procedural law. How you file your complaint and what the paper has to look like, what kind of font you must use in your complaint when you file a complaint, either a civil complaint or a criminal complaint, can all be set by procedural law. All right, burden of proof is on the prosecutor for the state to prove guilt beyond a reasonable doubt in all criminal cases. It's required by the federal constitution and the state constitutions all. There is also the certain safeguards. We have a right as criminal defendants to cross-examine all witnesses against us. That's a Sixth Amendment right. We have certain presumptions and inferences that we use in the process. We presume people are sane. We presume that they are innocent until proven guilty. And we have burdens of proof. These are the burden to go out and produce evidence and persuade to a certain standard. These are all part of the adversary system. And so we diffuse this power in this system and by the fact that the prosecutor can file a case, for instance, but we have a defense attorney who can also make sure that a person is not found guilty without very good proof that they are guilty beyond a reasonable doubt, and that all of their constitutional rights have been scrupulously honored. All right, let's look at the rights of the accused. Crime prevention must take place without the violation of the individual rights and liberties of the person who is accused. And those are the four different Bill of Rights amendments that we are going to talk about. There's the right to due process, the right against unreasonable searches and seizures, and we'll go on to all those rights against involuntary confessions, all this sort of stuff. We'll go through all those in more detail later. But that's the first thing that we have to do. These are rights of the accused. Also, this restricts the government power because these rights have to be scrupulously honored. And so, police cannot just walk into your house one day and start searching. You have to have a search warrant, as a good example, for instance. And that's one of the rights of the accused. They just, if you go into someone's house, except under really rare circumstances, you better have a warrant or you're not going to go in if you don't have consent. All right, so let's see. Key examples of right to remain silent is one of the rights of the accused. The right to have a trial by a jury is another right. The right to counsel in criminal proceedings, those are all rights, and we have plenty of them. One of those is to due process, which is very broad and has a very elastic meaning, because due process just means that you'll have a right to a fair trial. The trial will have to be fundamentally fair. So a person should always be given notice of any charges that are brought against him or her so that they can defend themselves and be prepared to defend themselves. And then a person should be provided with a real chance to prevent his or her side of a legal dispute as part of due process. And no law or government procedure should be arbitrary or capricious. It should be done for very good and important reasons. That's what the Due Process Clause requires. Criminal procedure amendments, there's a Fourth Amendment. That's against unreasonable searches and seizures. You have the Fifth Amendment, which is against double jeopardy and self-incrimination. The Sixth Amendment, the right to a speedy, public, and fair trial. The Eighth Amendment, which is no excessive bail, fine, cruel, or unusual punishment. These are the rights of the criminal defendant in any criminal case, both in state and federal systems, based on the Constitution. These are limitations on the power of the government. They have to scrupulously honor these rights. Okay, so if we want to introduce you to criminal law, let's first think about civil law. Civil law is law between private parties that has certain duties, obligations, and certain rights attached to it. And if those are violated in any way, then people have a right to sue each other usually for money, sometimes for orders or injunctions, ordering people to do things or not do things. But they involve things like contracts, torts, which are something like auto accidents, your domestic relations, which is like family law, property law. These are all areas where people can find themselves in controversies, and we need the courts to go out and resolve them. But no one goes to jail in a civil case. Okay, that's one big distinction here. Then we have criminal law, which involves felonies, misdemeanors, and other smaller violations of all kinds. And those are where there's a penalty exacted, whether it be a fine, whether it be putting someone in jail, in prison, or putting them to death. All right, let's look at the elements of a crime. The so-called corpus delicti, which simply means the body of the crime. In essence, the body of the crime is what is made up of elements or pieces, each piece of which is a part of the definition of the crime. For instance, burglary has two elements. First is entering a structure, and number two is with the specific intent to commit a theft or a felony within the structure. Those are the two elements of the crime of burglary. One of them is an actus reus, which means the guilty act, and one of them is the guilty intent or guilty mind, the mens rea. The mens rea is the specific intent to commit a theft or felony within the structure, and the actus reus is the entering of the structure. And there has to be a union of the act and intent together. They have to come together at the same time. And then usually there has to be some circumstances that are involved, depending upon the definition of the crime, and there can sometimes be results that have to happen before we have the crime. Sometimes, for instance, you may have a DUI with injury as a crime. You have to both be driving while drunk and cause an accident that ends up harming someone in some significant way for that crime. In that case, it would cause a result. Not all crimes require results. Not all of them have attendant circumstances. Sometimes they simply have a single act and a single state of mind, and as long as those come together, you have the crime, such as in burglary. Okay. Now, criminal defenses, there are many. First, there are alibi defenses, which is simply saying you got the wrong person because I was out doing something else at the time this crime took place, so it was impossible for me to do the crime. Another one is a mistake of fact defense, where what happens is if you think something is, let's say, you own a piece of property, and therefore you take off with it thinking that it is yours, and then that's not a criminal act because you made a mistake of fact. It may be that the theft statute says you must take the property of another. If you think that you are taking your own property, you're not committing the act because it was a mistake of fact defense. There's also a necessity. This necessity defense is a balancing process. Let me just give you an example of what it's like. Let's say that a woman is walking out of a bar alone in the middle of the night. She's a little tipsy, probably too tipsy to be driving. If she gets in a car and drives, she's going to be DUI. But she's not so tipsy that or so drunk that she can't drive a vehicle. At least reasonably safe, not perfectly safe as we all know, but at least can probably make it home. Then let's assume someone follows her out of the bar who wants to rape her and says, "I'm going to rape you," and she runs into the car, gets in the car, and drives away. Well, she might normally be prosecuted for DUI, but she might bring up the defense of necessity, and that is, yes, I did a criminal act, but I had to do it to preserve my life, which is much more important than the danger to society that I had sort of put myself into because of my DUI status. And if a jury balances it and what they needed to do was so important, such as saving someone else's life or saving their own life, that might be sufficient for them to be absolved of the criminal case. Also, the defense of justification, typically the best one you know about is self-defense. Yes, you can actually commit a homicide if you have a proper self-defense defense. If you had to do it in order to preserve your life under circumstances where the law would allow you to do that, then you are absolved from the crime. There are certain procedural defenses which typically use the exclusionary rule, which are so-called technical defenses, which is where the cops just did something illegal. The evidence now is suppressed, and so you defend the case on the basis of the fact that they, judge, please exclude the evidence because it was taken illegally. There's no evidence, and you walk away. There's also defensive excuse, typically infancy, maybe mental retardation or possibly mental illness can excuse you from crimes, especially even homicides. Yes, if you are insane, for instance, that's an excuse to get you out of the crime. Yeah, we may put you in a mental institute, but you're not going to get convicted of the crime. Juvenile delinquency is a possible defense. It's possible that you may not be sufficiently well enough established mentally to be able to understand that you're doing a criminal act, possibly. Then the insanity and mental illness is the one that we use for typically for homicide cases where someone does not understand what they're doing or that what they're doing is wrong. All right, let's look at the law on the books versus law in action. Law on the books, that's the legal and structural components of the judiciary that involves constitution, legislation, which are statutes, regulations, which are from administrative agencies, and court cases, which is common law. This is the law that's on the books. If you want to go find it, you can actually find it in a book somewhere, and it's all there. Okay, that's what the law on the books is. Now let's look at law in action. Okay, law in action. It focuses on the human factors governing the actual application of law, which is, this is where police, prosecutors, judges, victims, witnesses, and jurors all can bring in lots of different human factors. For instance, a police officer stops someone for speeding. That officer can give them a ticket or decide to let them go because they don't think they're going to do it again and they're really remorseful for what they did. Okay, that's the human factor. That's the law in action. Prosecutors can do the same. Judges could do the same, believe it or not, as well. They can actually dismiss a criminal case even if the prosecutor doesn't want it, doesn't want to see it dismissed. Judges can do that. Victims can not report the crime, or they can ask the prosecutor to not file it. That may not be that they may not be able to convince the prosecutor not to file, but it's possible that they could. Witnesses can, also have something to do with, bringing out different factors and what's actually going on and so on. And jurors can actually give a verdict of nullity, basically. They can say, yes, we know that they did it, but you know what, we're going to still come back with a verdict of not guilty. They can do that. Even if they know the person's guilty, beyond a reasonable doubt, they can decide to come back with a verdict of not guilty, and there's nothing anybody can do about it. So that's the difference between law on the books versus law in action. Okay, let's look at the crime control model versus the due process model. Those are two different ways of looking at the criminal justice system. And if you look at the Trayvon Martin case, that might have a good way to maybe put this into perspective. Now, Trayvon Martin was the victim in the George Zimmerman case. He was the black youth who was shot by George Zimmerman under the Stand Your Ground law in Florida. Now, if you use the crime control model or the criminal justice system, you would say, well, the Stand Your Ground law, is a good law because it will be essentially making it less likely that people who are doing suspicious things will end up committing crimes and getting away with them. And so we want to control crime, so we should do whatever we need to do in that regard. Okay. If you use the due process model, that means that people have a right to a fair trial. The next question here is, did justice get served here in the case of this victim, Trayvon Martin? Well, you could easily argue that justice was not given out in this case, because here's a kid who just went to to 7-Eleven for a drink and something to eat, who's followed by some guy who thinks he's doing something suspicious, and may have something to do with the fact that he was black and he was young, and he was in a neighborhood where this guy Zimmerman didn't like him being in there, and here the next thing we know is he's following Trayvon Martin, and possibly making Trayvon Martin think he's something really bad is happening, so he starts beating up on George Zimmerman because this guy's following him around, which you just don't do if you want people to think you're okay. And here you got now a fight going on, and Trayvon Martin would have no idea that George Zimmerman was holding a gun, and that he was going to end up shooting Trayvon Martin and killing him. And so, is this a fair trial? Was justice done in this case? Perhaps not. So that's the difference between the crime control model versus the due process model. Crime control model is we have to do some things that are not so nice sometimes to get crime under control. Due process model says no, we should only be doing things that are fair, right, and just, no matter what. And the goal of our process should always be fairness and justice. And that's how we would look at the criminal justice system. So these are two different ways of looking at the system, essentially. Now, in the crime control model, it's a conservative model and proposes harsher penalties and more power for the police. The due process model is what we call a liberal model, advocates social programs aimed at reducing crime by reducing poverty as a way to deal with it, rather than going after people who are committing crimes, because what's going to happen? You're going to put a lot of people away who are just poor, essentially. That's what they think in the sense from the due process model point of view. Now, the crime control model it emphasizes individual responsibility, self-control, discipline, quickly determining innocence or guilt. Informal fact-finding is considered foolproof when we know it's really not. Speed and finality of the courts is very important to this. When you have speed and finality, that usually means that we're not so concerned about other people's rights and scrupulously honoring those rights, because speed can make that happen. And then courts, of course, courts are hindered in effective law enforcement and provide inadequate protection to society. So we have to, help them to do better, kind of thing. Due process model: protect the rights of the individual as the prime directive. Understand social influences that cause crime and go in and change those rather than prosecuting people for those kind of crimes. Use formal fact-finding and careful consideration of each case so that we get more likely truth than falsity. Consider the courts to find error on the part of the law enforcement and prosecutors, or consider the courts are there to find error on the part of the law enforcement and prosecutors, and dismiss cases where they have done things illegally. And then consider community-based sentencing so that people can be kept in the community and rehabilitated that way. That's the due process model. All right, let's look at models of justice. There's a J.C. Dugard case. He was kidnapped at age 11, and by the age of 15, she had 2 children by her kidnapper, rapist, this Philip Gardido. Philip's wife Nancy also took part in the kidnapping. J.C.'s was found in 2009, and both Philip and Nancy were charged with the crime. For this particular crime, the loss of the child's entire childhood and mental well-being, which model of the justice system would you use in this case? Now, this was a real heinous crime, to say the least. Kidnapping a kid and raping this poor girl for years. When she's finally got brought back, she's never going to be the same. And these people have no excuse for this sort of conduct. This horrible sort of stuff. Do you really want to protect their rights? Maybe not. Do you really want the law to be enforced? Probably. Well, you decide the question, because it's depending on which way you look at it, you can see that this one presents the issue in stark contrast as between the crime control model and the due process models. All right, let's look at media depictions and distortions of the criminal courts. I got to tell you, I've been a subject to it because I've been a prosecutor for 23 years. I can tell you as a fact that the media will make a story out of something not necessarily out of whole cloth, but they will make it up. If it is not interesting enough, they'll simply distort it. I've seen it happen with me countless times, being interviewed and then listening to what the actual story was on the media. The differences were dramatic, and they did it for obvious reasons of making the story more interesting than it actually was. It happens all the time. Now, most people in the United States learn about the process of criminal courts through the media, and so they're seeing this process through the media. Lots of distortion going on. I can just tell you, as a fact, it is happening all the time. You know, there's an old saying in the media, don't let truth get in the way of a good story, and they really mean it. That's because they get paid because of ratings. They get paid because people buy their publication or watch it, and so their advertisers pay them for it, and so on. The advantage of this is that people are able to understand influences on the outcomes of cases, such as influences of the laws on the books, law in action, law in controversy. Disadvantages: the media can distort reality and make dull proceedings seem more dramatic than they really are, and they do that all the time. It's unfortunate because people are getting a real dishonest look at what's actually going on in the criminal justice system very often. Not always, but very often. And so that's about it for chapter 1. But I want to leave you with this one last issue, and that is you in the criminal justice system are going to have to deal with this issue. I want to tell you, because you're going to be in the system, and there's going to be days when microphones are going to be put in your mouth, and you're going to have to start saying something. And then so watch the story when it comes out and see if I'm not right. Okay. All right, that's it for right now. And again, if you have any questions or have any issues with the learning for chapter 1, please feel free to email, text, or call me, and I'd be more than glad to help.